session, all the slides will be sent out along with the recording. So that should be available to you either later today or tomorrow.
On a webcam. Oh, not be long, hopefully half an hour.
So as I said, the topic today is changes to holiday pay that have come into place at the beginning of this year. We've got the Employment Rights Revocation and Transitional Provision regulations, which came into effect on the 1st of January. And that covers a variety of areas that have been affected by Brexit. But one of those areas is holiday pay. And as I say, the changes came into effect from the 1st of January. You might have heard towards the end of last year about the case of the Chief Constable of the Police Service of Northern Ireland and Agnew. That was actually heard relatively early last year, but the decision wasn't issued until the very end of the year by the Supreme Court. So that's the highest court in the UK. And that case is best known for rejecting the notion that breaks of 3 months or more between periods of holidays ends the right or breaks the right to make a claim going back the way for underpayment of holiday pay where you've had a series of underpayments. And that was relevant to the cases involving, overtime and commission, where people were trying to historically claim back for holiday pay they hadn't received. And it was previously thought that if there was a gap of 3 months or more between them taking leave, they lost the right to claim back the way. But the other thing the Supreme Court decided that isn't so well known, I think nobody talks about it because it's in the too difficult box, quite frankly, is that unless it's somewhere specified, for example, in the employment contract, that every day of annual leave is a composite day. This is a new concept. You'll remember that under the working time regulations, there's 2 types of leave. There is the 4 weeks leave, which was granted by Europe in the Working Time Directive, brought into force in the Working Time Regulations. And that's 4 weeks or 20 days for people who work full-time or pro rata for part-timers. There's also, in addition, the additional 8 days that the UK government... Sorry, I've been told nobody's seeing my slides. Let's try this. Is that better?
Yes.
Sorry about that. But you haven't missed anything. It's just the first slide I'm on. So, we've then got the sort of second tranche of days that were added by the UK government, sort of gold plating on the European provisions, the additional 8 days or 1.5 weeks, which are under Regulation 13A of the Working Time Regulations. And a lot of companies, or most engineering companies, tend to offer additional contractual days on top of the 28 working time days. So they're like contractual days. So what the Supreme Court says, unless your contract says otherwise, every day of holiday is made up of a proportion of the 4 weeks, a proportion of the 8 days, and a proportion of any additional contractual leave. So you've got a kind of composite leave. Now that sounds all a bit far-fetched, but where it does kind of kick in is where people maybe have sick time off, long-term sick, and they're not able to take all their holidays in a holiday year. So for example, somebody maybe manages to take 5 days of their annual leave, but they're not able to take the rest of their annual leave when they're off long-term sick. And as you will remember, if you're off sick from one holiday year into the next, you can carry forward up to 20 working time days under the European case law. So previously with that example I'd given you, where somebody had taken 5 days off, you'd have gone, well, they can carry forward 20 days, they've taken 5, so actually they're carrying forward 15. But if we're talking about composite days, where, say, for example, only 80% of every day is made up out of the 20 days, that means that 5 days isn't 5 days anymore. 5 days is really only probably 4 days, but it involves some horrible fractions to work it out. So if anyone's dead keen, I'll send you something to help you work them out. But I think every sort of commentator I've spoken to about this has said this is really unworkable. So basically, what is recommended is that employers should just sort of stipulate that in every leave year, the first 20 days are the regulation 13s, i.e. the 4 weeks that you're allowed to carry forward if you're sick. And that makes it a lot more straightforward. So it's a bit of a complicated scenario, but it's introduced that concept of composite leave. So I think the takeaway from it is it's probably a good idea for companies to prescribe in some way, whether it's in your employment contracts or whether it's in a policy or simply a notice you put out at the start of the holiday year, that you actually lay down when each type of leave is going to be taken. So you might say the first 20 days somebody takes in each leave year are the regulation 13 days, i.e. the 20 days due under the working time regs. The next 8 days you take on top of that are the additional 8 days under regulation 13A, and any additional days your company offers by way of contractual leave are taken last. So there's a thought for first thing on a Wednesday morning. If anyone wants to speak to me offline about that later, then please get in touch. I'm not going to try and put up some calculations on this screen. So the next thing that's been changed under the legislation that came into effect in January is there's now a legal definition of normal remuneration. Now, that was already in case law because there was case law that said that holiday pay had to be calculated based on normal pay, but there was nothing in statute. And now that the legislation has indicated that there'll be a 52-week reference period. And as you'll recall, normal remuneration has to be paid for the 20 days of the working time regulation leave. Anything else, you can pay at basic pay if you want, or some other method of payment. But for the 20 days of regulation 13 leave, it's got to be based on normal remuneration. So the legislation now stipulates that the reference period is 52 weeks, which includes workers with normal working hours. Previously, it only covered workers engaged in either piecework or who had no normal working hours, but now everybody is included, which is a difference from what the case law was telling us before. So the legislation has been intended to bring things into effect that have been decided as case law, but in some cases it's done it by going a bit further, and this is one of these examples where it's gone a bit further than simply implementing the case law that European courts have showered on us over the last sort of 5 to 10 years. So what counts towards calculating normal remuneration? That's also now defined in the legislation, and it covers commission or other payments which are intrinsically linked to the tasks a worker is required to perform under their contract. So that's the first sort of part of the definition. It also covers payments for professional or personal status relating to length of service, seniority, or other professional qualifications. And it specifically covers overtime payments which have been paid regularly to a worker in the 52 weeks prior to the calculation. Now, again, there's no definition of regularly, and regularly can mean a whole lot of different things. So even if you only pay overtime once a year, but it happens in the same month every year, that might be sufficient to meet the definition of regularly. So I tend to find it's probably easier just to count all overtime payments, because if they're pretty rare, they're not going to make very much of a difference. I suppose the other thing to note is that the definition regarding commission and other payments connected to the tasks people are required to do as part of their role, that now gives scope for arguments that would now include an annual bonus, which historically wasn't the case even with the European case law, because what it was possible to argue previously was that there was no disadvantage to employees taking annual leave as far as calculating their bonus was concerned. And as you'll recall, the working time regulations and holiday provisions were all about making sure that people took an appropriate break from work. It was about health and safety. So for most bonus schemes, people weren't disadvantaged by taking that annual leave. Therefore, you could argue there was no need to include annual bonus in calculating normal pay. But that now seems to have been wiped away by that previous definition, which is commission or other payments intrinsically linked to the tasks the worker is required to perform under their contract. But one way around this might be to consider the wording of your bonus provisions to try to make clear it's not intrinsically linked to tasks that people are required to undertake. So that's a new concept again there under the working time, under this new legislation, which has introduced, or was intended to introduce, the case law which was given to us by Europe, but in some respects has gone a bit further again in this particular area. There's some new definitions, some new concepts again in the legislation. So we've now got the concept of an irregular hours worker, because you'll remember that the working times provisions and holiday pay provisions don't only apply to employees, they apply to workers. So people who maybe are personally obliged to provide their services to you, they can't provide a substitute, might be covered. So it's people with lesser rights than employees, but more rights than a purely self-employed contractor. So there's a definition of an irregular hours worker, and that's a worker who, in a situation where the number of paid hours worked in each pay period during the term of their contract in that particular leave year is, under the terms of their contract, wholly or mainly variable. So that would include your 0 hours contract people who you're entitled to either offer work to or not to offer work to, and any work you offer them might be different durations every week or every month. So it will cover those type of people. And it also covers part-year workers. So people who, under the terms of the contract that they have with you, they're required to work only part of the year. And there are periods during that year, while the contract still exists, of at least a week when they're not required to carry out any work and for which they're not paid. But that won't include situations if you've got people who are like term time workers who only work during school terms, where you smooth their payments across 12 months, so they just earn slightly less every month to account for the periods that they're not actually working. But it won't cover those people because they're paid for every week and every month, even though some of the time they don't actually work. You've got to have a situation where they're not actually paid for at least a week when they're not required to work during each year. But there may be some categories of worker where that applies. So these are new definitions. And there's some additional provisions around that category of worker. So those workers can't accrue more than 28 days of annual leave in any leave year. And they are allowed to recover payments in lieu of holiday on termination, and also we can recover if they've taken more annual leave than they're entitled to in the leave year. There's now provision for those categories to carry forward any leave, not just the extra 1.6 weeks, which applies to any regular hours workers. So they can carry forward all their working time leave and contractual leave for that matter, if they wish to. The other thing that the new legislation introduces, I just wonder if we could all put ourselves on mute. I can hear somebody in the background there. Thank you very much. In the background of these new definitions, the concept of rolled up holiday pay has been reintroduced, which, to be fair, I think a fair number of companies did continue with, even though that was made illegal by the working time regulations. You weren't allowed to pay rolled up holiday pay. The only time you could kind of pay in lieu of holidays previously was when somebody left employment, or in respect of any contractual leave. You could buy that out if somebody didn't take it and you agreed with them, you would pay for it instead. But for irregular hours workers and part-year workers who are caught by those definitions, the concept of rolled up holiday pay is reintroduced. And to be honest, it does make sense, because sometimes it can be quite hard to calculate holiday pay for those two categories of employee. Now, this only applies where holiday years begin on and after the 1st of April 2024. So if your holiday year started this January, on the 1st of January 2024, these provisions won't actually apply to you until January 2025 when your new holiday year starts. So in this situation, what you do is pay holiday pay at the same time as you pay normal earnings, whether that's weekly or monthly, and you add a 12.07% uplift each pay period, and you must itemise that as holiday pay on the pay slip. There's different provisions to deal with rolled up holiday pay when somebody's sick or on statutory or family leave of some description, which I won't go into the detail of. But what you need to know for now is that you can, for rolled up irregular hours or part-year workers, pay rolled up holiday pay at 12.07% uplift for each pay period, as long as you itemise that on each pay slip. So the next changes were in relation to carry forward of annual leave. Now these are the current provisions, and these will continue to be in place for carrying over annual leave. So a worker who's in statutory leave, so maternity leave, paternity leave, shared parental adoption leave, if they're not able to take the leave in the current leave year, which is quite common with the longer periods of leave, they can carry forward all their leave, all their annual leave into the following holiday year. The next category is the workers who are on sick leave, sort of long-term sick people who can't take sick leave during the current holiday year can carry forward up to 20 days into the following holiday year. So those two things will continue under the new regime. But what is new? And these are new provisions. So somebody who doesn't take leave in the current leave year, or who takes leave but they're not paid for it, can carry forward that leave if the employer fails to do any of these things. So firstly, if the employer fails to recognise a worker's right to annual leave or allows them to take the leave but doesn't pay them, and that covers the cases where the employer has wrongly designated the worker's status. For example, you've regarded them as a self-employed contractor who doesn't have rights to annual leave, but you've sort of miscategorised them. So if an employer brings a claim about employment status and they're found to have been a worker or an employee, and you've not recognised their work to annual leave, or you failed to pay them for any leave that they've taken, then they can carry that forward, that leave into the next holiday year if they can't take it in the current leave year. Now, the other two things which really are quite new are that you must have given the worker a reasonable opportunity to take the leave, or have encouraged them to do so within your current holiday year. So that might hit you in situations where maybe you've had an unexpectedly busy period and you've asked people not to take annual leave, and people maybe haven't taken their annual leave earlier, and they've then lost the opportunity to take certain annual leave again. They can carry forward that annual leave into the next holiday year. And that deals with the working time leave, the statutory leave, both the 20 days and the 8 additional days. Anything contractual, you can agree with the worker what you do with that. The other thing you've got to do is inform the worker specifically that if they don't take their working time leave, that is the 28 days by the end of the leave year, and normally there's no other reason which applies which would allow them to carry forward, so it will be lost. So you've got to tell them that. You've got to say, if you don't take this leave by the end of the leave year, then you'll lose it. And if you don't do that, they can carry it forwards. So that's your sort of people who historically just don't take the leave, who hoard the leave and want to take it forward because they want to take a longer period of holiday next year. That kind of can deal with those people. So in this situation, you've actually got specifically to tell them. So I guess employers should be putting out notices at regular basis, on a regular basis, to workers and employees during the course of the year, perhaps every quarter, a brief reminder to tell people that you have to start taking your leave, because if you don't take it by the end of the leave year and there's no other reason that applies, it'll be lost. And those carry forwards are limited to the end of the first leave year in which these failures don't apply. So you sort out your status issue. You start encouraging people to take their leave, and you remind them that by the end of the leave year, if they haven't taken the leave, it'll be lost. So you've got to do those things, or you run the risk that people have the right to carry leave forward. Another small change relates to leave which was carried over due to COVID. You remember back at the beginning of the pandemic, if you can remember that far back, that there was legislation enacted to allow people, if they weren't able to take annual leave due to COVID-related reasons, they could carry it forward into the next 2 years rather than just over into the next 1 year. And that kind of rolled on up until now. But now, from now on, from 1st of January 2024, there's no longer ability to accrue leave for COVID reasons. It was intended to apply to people who genuinely couldn't take leave because of COVID restrictions, people who are working in frontline services such as NHS or care homes who are being asked by their employers not to take leave because they were just so busy. But it also applied to our companies where people didn't want to take holidays because they couldn't go anywhere in the first 2 years. But from 1st of January 2024, that reason no longer applies. They can't accrue leave that they can't take because of COVID, because there's no restrictions on travel, and there shouldn't be any reason for people not to be able to take their leave any longer. People who've got still leave hoarded up for that reason can take it before the 31st of March. And people whose employment terminates on and before 31st March 2024 who've got that leave saved up can claim and pay in lieu of any remaining entitlement they weren't able to use due to the impact of COVID. So that's another small change. And then the last small change I want to bring to your attention is that the government has clarified that there's no longer a requirement for employers to keep records of all daily working hours for all workers. So what you're now required to do is keep adequate records of daily working hours, and that's presumably so that you can prove compliance in relation to people taking holidays, taking rest breaks, and daily and weekly rest breaks. But I think that does ease the burden slightly for employers. So that really ends the topics of update, which is a bit of a hodgepodge of matters relating to holiday pay and ability to take holiday pay. So if anyone has any questions, I'm going to kind of end the slides for now. And go back to this. So if anyone wants to pop any questions into the chat, happy if you want to come on camera as well. Don't know if anyone's got any chat. Just a question, the slides will be forwarded out to everyone who signed up for this session after the session's finished, probably later on today or tomorrow. So you'll get a copy of those slides that you can have a look at, and you'll also be sent a copy of the recording. So I've got the question, if the year runs January to December, 1st January is a bank holiday, how does that fit with the approach we recommend? The working time regime doesn't make any difference between bank holidays and statutory days. So you can, if you want, say that the statutory holidays at the start of the year are part of the first 20 days. Or if you want to do it differently, you can say, well, we'll exclude bank holidays from those first 20 days, and it's the first 20 days you take apart from bank holidays. But basically, it's up to yourself. You can make those statutory days part of the first 20 days if you wish to. And somebody's saying, where should it be specified? I guess you can specify it in the contract, or you could specify it just in a notice or a policy, because it's not a contractual change. It's just simply telling people when they have to take what type of holidays. You're not sort of diminishing the benefit in any shape or form. You're just prescribing when they should take which holidays, and I think that's perfectly permissible because you are actually allowed to dictate under the working time regulations when people actually take holidays at all. This is simply saying what type of holidays they take when, so it's less prescriptive. Any other questions? Hopefully not too difficult, because this is quite a difficult topic in some respects. Or is everyone just now thoroughly depressed and ready to get on with the rest of the day? I'll just very briefly highlight that next month's webinar, which will be on the 6th of March, will be about connecting with the next generation of engineers. And it's going to be hosted for us by an organisation called MCR Pathways, who are a charitable-based organisation who specialise in linking with children who are still at school, providing them with mentors, children who are disadvantaged who might otherwise struggle at school, struggle to move on to the next stage, to give them some help in school and beyond, and hopefully help them progress either onto full-time employment, perhaps apprenticeships, or college or university. That's what they do. So hopefully help for employers to connect with the next generation next month in March. If that's all the questions we have, I'm just going to thank you for your attendance and wish you all the best for the rest of today. Thank you for joining. Bye.
Thanks, Lindsay.
Thanks, Lindsay. Bye.
Thank you, Lindsay.
Thanks,
Thank you.
Lindsay.
Bye.
Thanks. Bye. Thank you.
Thank you.